Hey everybody, this is Jeremy McCarthy. I'm here to give you a quick overview on some of the major changes to the independent contractor market in California. So, I am the CEO of Coffee.hr. That's an employer of record service that payrolls employees globally. Also, a Venture Workforce Solutions, a PEO that does outsourced payroll benefits and HR for US based companies. I was a former CPA with PricewaterhouseCoopers. I'm a licensed insurance broker, 20 plus years of experience with payroll benefits and HR, and I'm also not an attorney, so don't sue me for anything that is not exactly as the law is written. What is an independent contractor? So, just a quick overview. Independent contractors are not treated as employees, so you don't have tax withholding, you're not required to provide any benefits, no compliance with federal, state, and local employment laws, no W 2 or payroll tax filings, and you typically issue these people a 1099 form annually that reports the amount of money that you paid to them during the calendar year, and you're not required to get workers' compensation for them either. The current reckoning. So, in the last few years, there's been a lot that's changed within the independent contractor market in California. The California Supreme Court, in the Dynamex case in 2018, essentially rewrote the law in how independent contractors should be determined. And the ruling was retroactive, which means that at the time of their ruling, they would look backwards if you had not been in compliance with the new way that they deemed you should review your workers for independent contractor status, that the changes and the penalties and everything else could be applied retroactively, which was interesting to say the least. California lawmakers then passed AB 5 to catch up to the court ruling, and it's essentially made it almost impossible to qualify as an independent contractor in California. ABC. So, when the Supreme Court of California passed this new ruling in the Dynamex case, they declared that a new measurement should be used to determine whether someone is an independent contractor, and they called it an ABC test. The A in ABC is determining whether a worker is free from control. So, a worker who is an independent contractor would really need to be free of any control and direction of the hiring entity and operate freely and independently. Now, B is the real killer here, working outside the hiring entity's business. So this declares that in order to be an independent contractor, a worker that performs work is outside the usual course of the hiring entity's business. And it gives examples as someone who is a carpenter or a plumber or any other kind of contractor that's providing work completely unrelated to the company's business who's hiring them to do the work. So that means if you've got anybody in your company doing similar work to the person that you're hiring, that automatically disqualifies them from qualifying as an independent contractor. And the last one is just that the worker is engaged with the same kind of work. That means that the person you hire is customarily doing this type of work for other companies. They've independently established themselves as a contractor. Usually means that they've set up an LLC or some other entity to operate under. And it really is just trying to discourage you from hiring somebody that may have just resigned or been fired from another job and they're just coming on board in a different payment capacity as an independent contractor instead of a W 2 employee. So the California legislature subsequently passed AB 5 and AB 2257. So what do these really mean? So AB 5 essentially just codified the Supreme Court ruling into law. Now, of course, California being California, they worked with a number of special interest groups who got carve-outs and special treatment and did not have to comply with this. So you have some insurance agents, doctors, attorneys, direct salespeople, and more who were exempted from this new way of looking at independent contractors. And then there were additional 6 other carve-outs who were told that they could comply under the old version of independent contractor measurement known as the Borello standard. And then, of course, there were more special interest groups that came out and said it was unfair. They needed a carve out too. So there was another AB 2257 passed that offered more special treatment for more groups. Uh, the gig economy companies were not part of those carve outs, so they were looking at a pretty dire situation. This all became effective in January of 2020. And then there was Prop 22. You may remember in November of 2020, there was Proposition 22 that companies like Uber and Lyft and DoorDash and others put millions and millions of dollars into advertising to get this passed. And it did pass. But it only applies to app-based driver and delivery services. So nobody else is covered by this. And it allows them to be independent contractors on those platforms. And they must also get new protections and not just be treated as strictly independent contractors. There are other rules that are applied, giving them other benefits. Oddly enough, the effective date wasn't really clear in the proposition. I believe it's estimated to be around December 17th last year when this went into play. And all other independent contractors would still be subject to the AB5 standard. Interestingly, there's already been challenges in court to the Prop 22 ballot measure, so we'll have to see how that plays out longer term. What does this mean? Really, no independent contractors in California with very few exceptions. So those specific carve-outs, and for now, the Prop 22 gig economy companies, all others really have to be paid as W-2 employees, and they must be afforded all the employee benefits and compliance that goes along with it. What does that really mean? If you've been hiring people on a contract basis as independent contractors, it means if you can't comply with AB5, which it's highly likely you can't, unfortunately, you're now going to be subject to all these requirements and more. So payroll taxes, withholdings, W-2, workers' comp, ACA and mandatory benefits, sick leave, and there's different state and local sick leave requirements. CalSavers, where you have to send money from your employees to the CalSavers retirement plan or have your own 401k, unemployment insurance, expense reimbursement. California has a little known law. Many people are unaware of this, but you're required to reimburse your employees who are working remotely for their phone and internet expenses. Mandatory harassment training if you have 5 or more employees. The list just goes on and on and on. So can you just ignore this new law and pretend we're operating in the old way? You can, but you could go to jail. So that's not likely, but technically what's interesting, and again, something many people are unaware of, if you knowingly misclassify someone as an independent contractor instead of a W-2 employee, and you don't provide workers' compensation for them, there is a law in the books in California that holds the owners and executives of the company criminally liable for not providing workers' comp coverage if there's a major injury that would require coverage for workers' compensation. It's very rare that's invoked, but just know that that is out there and that really is a law. You can have other fines and penalties and interest on your payroll that you were paying outside of the W-2 requirements and employee requirements. You have employment taxes and back taxes, workers' comp penalties, other labor commission penalties for not providing meal breaks and rest breaks and sick days, etc. So where's this really going? California obviously does not like independent contractors. The California political spectrum right now, the environment is that they are not going to give up on trying to force out the independent contractor status. And it's always been a higher risk in California for independent contractor status, but now it really seems like it's almost impossible. Nationally, Biden-Harris administration supported AB5, and they've discussed the possibility of mirroring California at the federal level. So you may not be able to escape this outside of California either at some point. They personally wrote in the ballot measure to oppose Prop 22. and they've discussed possible restrictions on independent contractors using the National Labor Relations Board or other federal legislation. So this is not something that is confined to California, and with the current administration, it could be something that's applied on a more national level. So what are your options? You can source people outside of California for now until more restrictions may come into play at a national level. You can try and hire only workers who operate through an LLC or corporation, but as you know, that's rare. Most people are not looking to get that complicated and don't have the sophistication to set those up easily and don't want to pay the high expense of managing that. You can put them all on your own payroll, which can complicate things by requiring you to give them a higher level of benefits than you really have the budget to do. You can hire them through a temp agency, which is expensive, or you can use an employer of record like Coffee.hr, where you just hand over the worker to us, we onboard them, comply with all of the requirements at a federal, state, and local level, do the payrolling, filing, etc. However, it will be more expensive than just paying them as an independent contractor, but it certainly beats the exposure you have legally and financially if you get caught paying somebody as an independent contractor when they should have been classified as a W-2 employee. So that's the quick and dirty on what has changed in California and what your options are. Again, I am Jeremy McCarthy with Coffee.hr. This is just a list of some of the many things we do to keep you in compliance. We do payroll globally, so we can manage your global contingent workforce. You can reach me personally at jeremy@coffee.hr or our sales team at sales@coffee.hr. And appreciate your time and wish you the best of luck.